How is it you're back in custody?
Oh.
How'd you get locked up?
Oh, I was in Jackson County Jail and I did 60 days there for the retail fraud. And then they picked me up from there, Your Honor.
So you went in on you have the two retail frauds. So you went in on those
Yes.
retail frauds for 60 days.
Yes, sir.
Anything you want to say before I impose sentence?
Saipawan, Pratap Saipawan,
Yes,
and please state your name.
I'm Pratap Saipawan.
Right.
And Your Honor, we're here for sentencing. Probation said that they would provide the court with a copy of my client's assessment and program completions, which he's done. The recommendation reflects that he did his VIP and early intervention, etc. We ask the court to adopt the recommendation. He can pay those fines and costs today.
All right. Sir, is there anything you want to say before I impose sentence?
No, Your Honor.
Sentence of the court. Going to order $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs. You can pay all of that today?
Yes, sir.
All right, pay that today out at the counter. I'll order 93 days in jail. Credit 1. The balance is suspended.
Okay.
Thank you.
You're welcome.
Wait for me outside. Your Honor, may I approach the bench on another matter? I know.
Man,
Thank you.
there it is. Court does call the case, People versus Carlos Hicks.
Good morning, Your Honor. Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Hicks, who should be appearing via Zoom.
Hi, how you doing, Carlos Hicks?
All right, do you have a camera, sir?
Oh, yes, I do. I'm currently just getting off of work, so here we go.
Okay.
I'm currently on my way home. I'm just getting off of work, sir.
All right, very good. Go ahead.
Yes, Your Honor. I did have the time to review the PSIR with my client. We have no additional factual corrections, deletions, and insertions, so we would ask the court adopt the recommendation and probation.
Great. Mr. Hicks, is there anything you want to say before I impose sentence?
No, sir.
All right. Sentence of the court, place you on probation for a period of 12 months. You're to pay $555 fines and costs, $360 probation oversight fees. When can you pay that?
Currently, I'm trying to, I could have that paid month to month before I get off of probation. Can I have that 500 fully paid? Because
All right. Your payment plan is arranged by probation.
okay, I just do a payment plan with my probation officer.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Beyond Barriers or comparable program. You're to complete 25 hours of community service with proof to probation. You're to begin and maintain employment with verification to probation. I'll order 365 days in jail. Credit 51. The balance is suspended. All right. Thank you.
Okay, you're welcome.
Thank you, Your Honor.
Court calls case People versus Amanda James.
Good morning, this is Paul on behalf of Mrs. James. I don't see Miss James in the courtroom. I did speak with her. I have no explanation.
Bench warrant will issue. Oh, go ahead, Ms. Blair.
I was going to ask the court to issue a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. I'll give a 10% privilege on that. That warrant will issue immediately. Court calls case People versus Shaletta Keith.
Good morning, this is Public Defender Lauren Kearney on behalf of Miss Keith. Not sure.
Yep.
Well, I spoke with Miss Keith as well. She's planning on being here. When you send this, I don't have an explanation for her failure to appear.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. 10% privilege on that. That will issue immediately. Court calls the case People versus Neoplasters.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Plasters, who I believe is here. Mr. Plasters, state your name, please.
Neil Plasters.
Okay, thank goodness, huh? All right.
Your Honor, we did the sentence report. We ask that you adopt the recommendation.
Right. Sir, is there anything you want to say before I impose sentence?
Just that I was incarcerated for 6 months prior to coming here. I just got a job a month ago, and I know they wanted $800 to be paid. I get paid every Friday. I currently can pay around $400 right now on this $800 that I owe or whatever they want for restitution. But other than that, I
You
have
said
nothing
you
else.
have, you said you have $400 on that? I didn't understand that part.
Well, some are right around there. I have to check my bank, but yeah.
Okay. All right. Sentence of the court, $125 statutory fee, $800.08 restitution to Aaron Brown payable through the court. So you can get 400, can you get 400 to the court by Friday?
Yes,
And you get paid
I
for it.
can definitely do that by Friday.
All right, so 400 by Friday, the 24th?
Yes.
By July 24th, and then how would you pay the balance?
I would start, I guess, a weekly. I could do weekly payments. I get paid every week.
All right, so how much can you pay each week?
Well, I have court fines in Livingston County too. I could probably do $50 a week.
Okay, that's fine. So then $50 per week. I'll indicate that's to begin August 7th.
Okay.
Okay? And
All
then
right, thank you.
I'll order 90 days in jail, credit 90, sir. All right, thank you, sir.
Yes, thank you.
Mr. Plasters, please, that has to be paid in cash.
Yes. Can you where do I have to pay it at?
You can pay it at the 14A1 court.
At the 14A1 court?
Friday.
Yeah, the one by the sheriff's department from here.
Okay, and Hogback?
Right, yeah, Hogback.
Okay, thank you. I'll have that paid on Friday.
You know where that is, right?
Yes, yes, I do.
Okay, all right. All right, you take care of yourself.
All right, thank you.
Court calls the case, People versus Ralph Chappell.
Good morning, Your Honor. This is Lana Zarisma on behalf of probation. Your
Who?
Honor.
Yeah. Okay, go ahead.
For hearing on a prosecutor deferred sentence. He has completed all terms ordered by the court and his appearance has been waived. Probation recommends that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation with a.
You know, the way she was acting this morning, I just want to say no. I just and see what she does. I don't know. All right. Hearing no objection, so ordered. Court calls case of the People versus Nathaniel. Is it Laurent?
Yes. Good morning, Your Honor.
Good morning. What is he here?
Costs, yes. It's already received.
All right, sir, you are asking for additional time on your payments?
Yes, I am.
All right. Okay, I see what you're sending me. Are you working at this point?
Yes, I am. I'm currently at work right now.
Okay. So when you sent this in to me, you had said that you were going to pay $70 on July 7th. Did you get that paid?
Yes, I did.
Okay, and then you want a payment plan of $50 per month, right?
Yeah. Correct.
What do I have him going? I got
10:30.
10:30. All right. Given everything that's in there, I'll allow it. So I'll indicate defendant to pay $50 per month. When are you going to make your first payment? Would it be August 7th?
I get paid 2 times a month, so probably would it be okay to do that like towards the end of the month?
Okay, I get you.
Yeah.
All right. So what I'll do is $50 per month beginning August 28th,
Okay.
2026. All right. Thank you, sir.
Thank you. Take care.
You do the same. Court calls the cases, I think. Of the people versus Eric LZ Williams. Oh,
Good morning. Public benefit on behalf of Elsa Williams, soon say your name.
Eric LZ Williams.
all right.
Are we here for show cause here?
Yes. He owes on the case ending in 1229. We currently have a balance due 1187. And then on the other matter, I have a balance of 549.
Your Honor, I believe that Mr. Elsie Williams indicated that he was gonna make a payment of $200. Were you able to do that, sir?
Yes, I paid $200 this morning on the 1187 case.
On which one?
The 1187. I put 200 on it this morning.
That was the Ipsy case, he said. And I gave.
On the 1229. He put 200 on that one.
Yes.
Okay.
And Mr. Elsie says he's back to work. He says $50, he can pay $50 a week going forward.
A week?
Yes.
Is that right, sir?
Yes, Your Honor.
All right. So when can you begin paying that?
Next week.
So the 31st?
Yes.
All right. Defendant to pay $50 per week, beginning July 31st, 2026. Well, yeah, I'm gonna do that. So so I want you to pay that on the case that ends in 0378.
Okay. That's for the $500 in
Right. So we can try to get that one out of the way as quickly as possible.
Okay, no problem, Your Honor.
And then on the other case, defendant to pay $50 per week, beginning, well, it's going to be about 10 weeks out or so. 2, 4, 5, 6, 7, 8. Beginning October 9th. So get that other one paid off and then you can begin paying on this other one. Okay?
Okay. Yes, Your Honor.
All right. Thank you, sir.
Thank you.
Court calls case People versus Lamar Hampton.
Good morning. This is Public Defender Lauren Kearney on behalf of Mr. Hampton. Not checked in. Well, Mr. Hampton was in the lab hearing. Well, I don't know. If you remember it. It was just a few minutes after the hearing in my office. And he submitted the warrant recall on his behalf. I will say, he did make a payment. He's made a couple of payments in the last couple of months. I calculated everything. He has paid $300 since he was originally sentenced. The original sentence was $250, but because sometimes work the show cause hearings, he has gotten the warrant fees, late fees, etc. So he is making an effort to pay it off. Like I said, the original sentence was $250, he's paid $300. There is also an entry from April 29th that the court would consider waiving the balance to be paid $185, which he did do. So on behalf of Mr. Hampton, I know it's not here, but I have.
I already wrote it. Okay. No, but I'll let you talk if you want. I mean, all right. Although the defendant failed to appear, I'm going to waive the remaining payments. Court calls the case, People versus Keith Malone.
Good morning, this is Public Defender Laura Perry on behalf of Mr. Malone. All right, attempted to get in touch with Mr. Malone.
Oh, right there. He's been here all day. All day. How come you didn't know?
It's hard.
Yeah, the number we have for Mr. Malone is disconnected, so I wasn't able to get in touch with him.
Okay.
If it was about $800, I would ask you to tell the court what you can pay moving forward.
I recently was incarcerated. I'm seeking jobs, so I don't have anything right this minute.
Working right now.
No.
How long were you in?
I did 53 days in Wayne County, and then they transferred me over here on this case, and this case is 10 years old, and I was released from it, and I don't understand why. Like, I still had a warrant and stuff, so I didn't even know anything about it until I got put over. So this case like 10 years old.
What's my September date? Give you time to try to get yourself straight. So what I'm going to do is I'm going to adjourn this to September 9th. All right, 2026, 9 a.m. That way you can get yourself employed and you be able to come back and tell me what you can do.
Okay.
Fair enough?
Yes, sir.
All right. Thank you.
Thank you. I can give you a new number.
Court does call the case, People versus Amari McGee.
Okay.
Assistant Public Rose Buckovich on behalf of Ms. McGee.
Oh.
Oh, there she is. Hello, Ms. McGee. All right.
Yeah, I know today is the time and date for show cause. I was actually unable to speak to Ms. McGee for today's hearing, so I would ask her to explain when she'd be able to pay off the rest of the costs and fines.
All right, I have 825 due.
Yes.
So when do you think you can get that paid?
I'm on break from work for summer break, but I go back in. Starting date is August 31st. And I get paid bi-weekly, so I got my schedule for the first 2 weeks. So I'm thinking like maybe at the end of September I want to pay by the end of September. I want to pay like half of it, half of the remaining, and then my next check, the other remaining.
All right, so here's what I'll do. Defendant to pay $400 by September 30th. Okay.
Yeah.
Is that what you were saying? What were you?
Yeah, but can I get a little can we do payments payment plan?
Okay, I thought you were gonna just pay it all.
I do. I that's what I plan to do, but I don't want, if I'm not able to, because I got other responsibilities, I don't want it to be another, situation where I gotta come in.
Wow. That was insulting to me.
I'm sorry.
No, she first of all told me that she's got things more important than me. And then I don't want to come see you, Judge. Wow. It's okay. I'm hurt. All right. So you get paid every 2 weeks, right?
Mm-hmm.
Okay. So what can you pay every 2 weeks? Let's start with that. How much do you think you pay?
Say $100.
Okay. So every 2 weeks you can pay $100.
Mm-hmm.
Okay, you're starting work, what date? You said the beginning of September?
Yeah, well, August 31st.
Got it. Okay. And so here's what I'm gonna do. Defendant to pay $100 beginning. Well, you beginning September 25th. Got that?
Okay.
So here's what I was trying to do so that you know. Let you, because you probably not working and not having a check, you probably promised a lot.
Yeah,
With
that's
those
what I
up,
was thinking. But when I get my check, I'm gonna
I
try to pay more than that $100.
no, I
If
got you.
you know,
I okay. Listen, I'm trying to help you out, okay? Because I realize if you haven't been working, you gotta try to get things sorted and all kinds of stuff, and stuff comes up. So I'm not looking for you to pay anything out of that first check. That's why I'm gonna start it the last Friday in September.
okay.
Okay. And then you can then go every 2 weeks and get that paid. All right.
Okay. Thank you, Judge.
Okay.
All right, have a good
All
day.
right. Thank you.
Thank
You
you.
do the same.
Thank you, Your Honor.
That's it. You know what? I've been real nice this morning. That has to end. It doesn't make me feel good. I get uneasy when that. You know what? Flair.
Teresa Claire on behalf of probation. Your Honor, Ms. Fleming is before the court for a violation of probation hearing. Ms. Fleming had another positive cocaine test on July 1st. That was sent out for complication, which the lab did confirm that it was positive for cocaine. Probation asked the court for a bench warrant, and a no bond warrant was entered. Ms. Fleming was taken into custody when she reported to me last week. When I spoke with her regarding the positive test, she denies that there was anything with cocaine. I don't know if that's where her stance still sits. However, again, I provided the confirmation to the court of the positive test. At this time, probation is asking that the court revoke her probation and sentence her to 93 days of jail, credit for 82 days that she served to date, that she served the balance, waive remaining terms of her probation, accepting the financial obligations, and discharge her from probation without.
I did have a chance to speak with Ms. Fleming. We understand the recommendation. We're asking that you adopt it.
Ms. Fleming, anything you want to say?
Not really. I mean, I stand by what, and I understand your job and I understand everybody's job. So I just want all this to be over with, you know what I mean? I want to move on. So whatever we got to do.
Send it to the court. I'll follow the recommendation of probation. I will hereby revoke your probation. I will sentence you to 93 days in jail, credit 82 days served. You are ordered to serve the balance. I'll waive all remaining terms except the financial obligations. Discharge her from probation without it. Thank you.
Thank you, Your Honor.
Court does call the case People versus Terrence Powell.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Powell. State your name for the record, please, sir.
My name is Terrence Eugene Pupal.
Yes, please.
Claire on behalf of probation. Your Honor, Mr. Powell is before the court for a violation of probation hearing. Mr. Powell is in violation of the court order in that he owes a balance of $815. His last payment to the court was made in August of 2024. He failed to report to probation as directed, failed to complete the MRT program or a comparable program, failed to provide proof of employment, He has new criminal convictions out of the 29th District Court, both of those being open intoxicants in public. So there is alleged use of drinking, which is also a violation. Those date of offenses is August 29th of 25 and June 17th of 2026. He also has a new pending criminal case of curfew park violation out of the 18th District Court. That alleged date of offense is April 17th of 2026. He is on bench warrant status in that case. He also has outstanding bench warrants out of the 8th District Court, 33rd District Court, and the 18th District Court. At this time, probation is asking that the court sentence Mr. Powell to 93 days in jail with credit for 2 days served, that he serve the balance, waive remaining terms of his probation, accept the financial obligations, and discharge him without.
Your Honor, I was unable to speak with Mr. Powell prior to today. The contact information we had was not correct. I think Mr. Powell is hearing all of this for the first time right now. I'm not sure what he has to say about it all. I would ask maybe if we could pass it, I could speak with him for a few minutes and see if there's anything we can add, or if he wants a hearing on it. I don't know.
Do you want a hearing on any of this, sir?
What do you mean by a hearing, sir? Your Honor.
Well, there'd be a hearing as to the violations, alleged violations of probation. There would be a hearing conducted by the court to determine whether or not you violated terms of your probation.
Yes, Your Honor. I would like to set up a hearing.
Well, let's do this. I'm looking at here's part of the problem. Part of the problem is there's a no alcohol use. There are 2 convictions for alcohol use that are clearly on his record. So what I'm going to do is I'm going to remand the defendant at this time. I will stop the proceeding, allow you to speak with him as to whether or not he truly wants a hearing on the rest of these matters. But the court could see a clear violation of his probationary terms at this point in time. So defendant's remanded, and then I'll bring it back out. This is all on. That's it. Court does call the case People versus Michael Holbrook. Holbrook. Yeah.
Good morning again, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. Holbrook, who is now coached.
Good morning, Your Honor.
Morning, sir. Your name?
Michael Lee Holbrook.
Ms. Blair.
Please declare on behalf of probation, Your Honor, Mr. Holbrook is before the court for violation of probation hearing. Your Honor, Mr. Holbrook is in violation of the terms ordered by this court. First, Mr. Holbrook was sentenced before this court back in March of 2020. He has failed to comply with the court order in that he owes a balance of $2,455. Last payment to the court was in March of 2020, making a $20 payment. Failed to report to probation after March of 2020. Failed to complete inpatient treatment, failed to drug test as directed, failed to complete the victim's impact panel, failed to provide proof of AA meeting attendance, and he has had multiple prior failure to appear. I know that Mr. Holbrook has been arrested on warrants after his failure to appear multiple times. In all of those instances, Your Honor, he has not contacted probation after he's been in custody. He additionally has new criminal convictions and open intox in a motor vehicle of the passenger. That's out of the 12th District Court with the date of offense of March 7th, 2026. He has 2 retail fraud, 3rd degrees. Those are also out of the 12th District Court. Date of offense in those, one is March 3rd of 26, the other is March 4th of 2026. And he also has a disorderly person, also out of the 12th District Court. That date of offense is January 29th of 2026. Given Mr. Holbrook's failure to comply with the court order and his multiple failure to appears and doing nothing that this court has ordered, probation is asking that Mr. Holbrook be sentenced to 365 days in jail with credit to 43 days that he has served to date, that he served the balance, that he complete the in-jail Don Farm program, waiving remaining terms, accept his financial obligations, and discharging him from probation without imprisonment.
All right, before I hear a response, do we know how he now is in custody here?
I do not know that, Your Honor.
All right, thank you.
Your Honor, my client would admit to the violations in addressing the recommendation of probation. First, we would request the opportunity for my client to attempt to comply with his probationary terms. He would, if released, he would be residing in a household, would have family support, and would have a job lined up. He also reports to me that he did do 30 days of inpatient treatment at Bear River at the end of 2025, early 2026, around that December, January time period. So he would request the opportunity to comply with his probationary term.
30 days at Bear River. Did he complete the program?
Did you complete the program, sir?
Yeah, I got a certificate.
Okay, go ahead, Mr. Wickler.
Yes. He does acknowledge that he has not done anything on his probation yet. Apparently, in speaking to him, there may have been some confusion about this being reporting probation. However, obviously, I was not around during that time period. And the alternative, if the court is inclined to impose any form of jail sentence, we would ask for the consideration of an early release once my client completes the in-jail Dawn Farm program. I've always spoke to Agent Peralva about this, and she would have no objections to his early release once he completes that program.
How is it you're back in custody?
Oh,
How'd you get locked up?
oh, I was in Jackson County Jail and I did 60 days there for the retail fraud. And then they picked me up from there, Your Honor.
So you went in on the, well, you have the 2 retail frauds, so you went in on those
Yes.
retail frauds for 60 days.
Yes, Your Honor.
Anything you want to say before I impose sentence?
No, Your Honor.
The court at this time is going to follow the recommendation of probation. I'm going to order 305 days in jail, credit 43 that you served. I'm going to order that the defendant is to serve the balance. The defendant is ordered to complete the in-jail Dawn Farm program. I will consider his release. I'm making no guarantees upon his completion of that program. I'll waive remaining terms, accept the financial obligations, discharge the defendant from probation without improvement. Thank you.
Thank you, Your Honor.
Your receipt. Then she prints the last one. It was like one thing of donuts. I was like, did I really forget to pay? And now they're when they catch a retail fraud charge, and I know how hard it is to prove it was an accident. I tell myself this all the time. And then she's like, okay, I'm gonna call in a few minutes. Be a few minutes. Like, I know this is the beat. Like, what's going on? And then she called and she's like, okay, you're good. And then I walked out and they were checking literally everyone's receipts. Like, maybe it was just me, but I was like, did I really forget to pay this cell phone because I hear it? I know.
14A District Court, County of Washington, State of Michigan, back in session. Now, Judge JudgeSimpson about it.
You may be seated. And you define all your.
I'll save it.
Court does call the case, People versus Terrence.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Powell, who is approaching the podium. State your name for the record, please, sir.
Terrence Eugene Pupil.
Ms. Perry.
You and I appreciate the time to speak with Mr. Q Powell. We did have a good conversation. He kind of explained to me what has been going on in the past few months. I'd like to start off by saying, of course, Mr. Q Powell wants an opportunity to complete his probation, is asking to be released today. I will also say that he did just get out of Wayne County. He was there for 20-something days. Can't remember exactly. So if the court is inclined to sentence him to time, I would ask that the court consider sending him to credit for time served, for including that time, or giving him credit for that time. I can reach out to Wayne County and get proof of incarceration if necessary. That's where he was transferred here from. Since this case started, Mr. Pupel lost his biological mom. Since then, he's kind of been he's lived a very unstable life, and he's now kind of getting to the place where the pieces are back together. The gentleman that he was here with has given him some stable housing. If he were to be released, he could be released back there. His belongings are all there. He has been homeless on and off since the inception of this case. He recently got this housing. He secured a new job, so he is working construction. He also mentioned to me that his dog is at this house, and he's worried that these folks will take the dog to the pound if he's not released back to that home. We did talk a little bit about these other cases that he's had. The 18th District Court cases were why he was in Wayne County. He was sentenced to time served on those files. As for a couple of the other bench warrants, for example, the 8th District Court bench warrant is Kalamazoo. He believes that is not him. I remember looking this up previously. Actually, I believe it may even have different middle names on the files. The 33rd District Court case, he was scheduled for court that day that he was transferred here. And he missed that hearing because he was in transit. He is also enrolled in online university, studying 3D arts and graphic design. So he's got a few things going for him. I think Mr. Pupel understands that he hasn't shown up for this, but all of these things that have been going on in his life have prevented him from doing so. I mean, the last time I spoke with him, he was ordered to be here in person. He didn't have transportation to get here. And like I said, some of those pieces have been kind of coming together for him. So he is obviously at the mercy of this court and asking for another chance at this time. I know he said he may want to say something as well.
Go ahead.
Your Honor, life been kind of like rocky and rough for me, especially ever since I caught this case that I'm in front of you on. If you remember, I was living with my sister at the time, and I had no contact with my sister. I was outside homeless then, and I maintained a job. I was coming in, but I had to move from here, so I ended up losing that job, and I moved in with my big sister. And ever since then, though, like, cause she got a lot of people living there, I had to like leave from over there too. So I kind of been just bouncing around all over the place. Around that time, like when I was in court here, that's when my biological mom had passed. This year, my adoptive mom had passed earlier this Martin Luther King Day. And I know I'm asking for a lot, but I really want another chance at probation. Like, I'm about to be living back out here in Ypsilanti, so I shouldn't have no problem getting here. I'm in college, Full Sail University. I'm trying to study 3D arts. I'm kind of failing right now because I was just recently locked up. I'm like failing about like a month worth of schoolwork. I literally just started a job out here. Well, I got the job when I came out here, like, and I came out here to get ready to go to court. You know what I'm saying? So here I am in court. I know I got violations. I'm really asking for another chance with this. Like,
Well,
my dog is over there. I'm sorry, Your Honor. My dog is at this house. I really don't want to lose. I don't want to lose my dog. When I was on my way to come to court this morning, she said, if you get locked up, I'm gonna take your dog to the pound. So I wrote some numbers down like, hey, can you call these people for me? You know what I'm saying? And they can come pick my dog up. But I'm just not trusting it. I need that dog. Like, it's like my support system right now. That's all I really got. I got family, but like I'm adopted. You know what I mean? And my mom, she passed away now. So just because she adopted me don't mean that the whole family adopted me. You know what I'm saying?
I understand.
So but I'm back this way. I'm trying to transition and get back on my feet. Like I really just I want to do right in school. I want to get on with my life. I'm just trying to do better. And
All right. It becomes so that you understand something, Mr. Powell. It was over 2 years ago that I sentenced you. You've been on bench warrant status almost coming up in a couple months for a year. Through all of that, you have done absolutely nothing. I mean, not even the stuff that doesn't cost you anything to do, just contact probation. You've done nothing. Absolutely nothing. With the exception of then in 2025 and in 2026, when you should be here, should be trying to do it, you're picking up offenses. And then if that weren't enough, you pick up another offense. I mean, there's not a single thing here that in any way goes to your benefit to say you're going to do the right thing. Nothing. I don't mind giving people chances and things along those lines, but you got to kind of earn a chance to do something.
I'll say something, please.
Go ahead.
All right. So like during them times, I was homeless outside. Like I'm living outside. I'm not trying to give no excuse for it, but my life was just all over the place. Catching a new charge and stuff like that. It's a story behind it. But one of them, the most recent one, that was definitely me. But the other opening talks, that was not. I was with three other people, and there was a bottle sitting on the sidewalk, and they only wrote me a ticket. They ran my name. They was like, "You got a warrant out of Washington." I told them I understand that, but they called up here. I guess Washington didn't come pick me up, but then they wrote me a ticket. They ain't write nobody else a ticket that day, and like the curfew ticket, that was me just crossing through the park one day to get to where I was going to. And I guess because it was dark or something like that. I was with people then too, and they only wrote me a ticket. And I don't think none of that what I told you helps me, but I'm back. I'm kind of back getting towards being stable. I would just ask for another chance.
You know, when the officers picked you up and said you had a warrant, that was indeed an opportunity at some point to get yourself down here to contact probation.
Yes.
I sentenced you and you did nothing. That's the bottom line. I hear what you're saying, but you've done nothing.
It don't show me, it don't show that I reported at all. Cause I was reporting until my phone was off. But I was reporting up until I ended up losing my phone. Not losing it, but like losing my number and all that. I couldn't pay the bill, I lost a job, I was homeless.
Your Honor, he last reported in August of 2024. Being sentenced in May of.
In May of 2024. So you reported for 3 or 4 months, but then you stopped. And the problem is you knew you were supposed to be reporting.
Well, if I'm out here, can I like report in person though? Like, cause that was my part.
Well, you keep giving excuses and they're not, you didn't do it.
I understand.
Sentence of the court, 93 days. I'm going to send you to 93 days in jail. Give you credit for 2 days. You are to serve the balance. I'll waive any remaining terms except financial obligations. Discharge from probation without improvement. Defendant is remanded. Thank you.
Thank you, Your Honor.
You're welcome.
For these purposes.
Are the people going to have any objection?
No, Your Honor.
He was here for the hearing, and I guess certainly I think proceeding without the defendant, I think often one has to be cautious.
And Judge, one of the reasons why I think he may not be here is that he was here for that hearing and he was in contact with myself and Mr. Vincent about the motion that had been planned to be filed and argued here today. And then he was told that for our own reasons that we were not filing such a motion. And I just have thought that he might come in and say, well, I thought you said that there wasn't going to be a motion to myself and Mr. Vincent. I would hate to think that our advice was somehow misinterpreted that played into his absence today.
All right. Why don't I do this? I was going to rule today and then issue a written opinion on it, rather than proceeding in some fashion that there might be complaints a little bit later. Why don't I just indicate that going on vacation, that I'll issue a written opinion by August 3rd. And then that's how we can proceed. Okay. I feel more comfortable doing it that way, I think.
Certainly, Judge.
And then I don't know what other dates we have set in this.
I don't believe we have another date set yet.
I agree.
So why don't I do this? I will issue the written opinion by August 3rd, 2026. And then I will set a pretrial for no. Yeah, why don't I do it? Then give me the next date after that. I'll set a pretrial then on this for September 2nd, 2026.
Your Honor, on
You're out.
Mike and I are both conducting a homicide trial together in Third Circuit beginning on the 31st, if there was another date.
After the second.
The 16th. What's the one?
So set for September 16th, 2026. If I grant the motion, in case it may be that I'll cancel that pretrial.
Thank you, Judge.
All right, thank you. That's it for us for today. Court stands adjourned. Man.
Yeah, that was.
Still wish to plead guilty?
Yeah.
And to that charge, how do you plead?
Guilty.
You understand by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form? Did you sign an advice of rights form?
Oh, yes.
Any questions regarding any of those rights?
Huh?
Do you have any questions about any of those rights? Do you understand me or?
I understand you. Okay. She's terrified, y'all.
She's terrified? It's okay. Me too. All right. So you don't have any questions regarding any of those rights? All right. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal upright.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense? Get over your fear.
I prepared for her very well.
We did okay on that last part. Let me get my, where's the reason I don't have.
Wait.
You know what? I'm gonna leave. Come back and start again because I don't have. Just there. On the date of January 2nd, 2026, at the location of 2000 Waters Road, Field Township, Washtenaw County, State of Michigan. What do you do at the Target store that makes you think that you're guilty?
I was in Target, Pittsfield Township, when it was open to the public, and I took like about $444.
What are you reading off of? Gave you something to read. Okay, no, it's okay. Were you in the Target? Were you in the Target store?
Yeah.
Did you try to take something out of the Target store?
Yes.
All right. And this was merchandise they had offered for sale? And you tried to leave the store without paying for it?
Yeah.
All right. And as you said, the store was open to the public at the time, right?
Yes.
All right. And is this on value or on value? Okay. Was the total amount, you okay? Okay. Was the total amount of what you took from the store, was that in excess of $200?
Yes.
Yes? All right. Ma'am, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that? All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule?
Yes, sir.
Yes.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation report. Sentencing in this matter will be
July
8th, 2026, 9 a.m. Bond will continue. Survived. All right. Ma'am, do me a favor when you go out. Down on the left-hand side is my probation department. Stop in there before you leave the building, okay? Thank you. What, all those people came with you? All those people were with you? And you were nervous? You brought some big people too. They were tall. I don't know, you might have had to go. Court calls the case, people versus Dana Donovan.
Morning, Your Honor. Raymond Cook for the people.
This is an arraignment legal counsel. And voucher.
Not checked in. Given the nature of the charge, bench warrant will issue for defendant's failure to appear. Bond will be set in the, what is the alleged VHC in that?
0.108. No,
I'm sorry?
108, no crash, no priors.
Bond will be set in the amount of $10,000. She needs that.
Okay, that's the report for your recall.
What is this? That was the other one. Court calls the case People versus Dorita Richards.
Morning, Your Honor. Great with those people.
Dorita Richards. No response. I'll issue on this one in order to show cause. Court calls the case of the People versus Jomini Vanderloop.
Morning, Your Honor. Raymond Cook for the people.
No counsel, not checked in.
Bench warrant in this matter will issue for defendant's failure to appear. Yeah. Bench warrant will issue for defendant's failure to appear on this one. Bonds at the amount of $5,000. Give a 10% privilege. Court does call the case People versus a Duraman Banda.
Morning, Your Honor. Raymond Cook for the people.
Rob Brown appearing on behalf of Mr. Vonda.
Your name, sir?
Up there, man, Bamba.
Thank you. What are we doing?
Here, I'm requesting an adjournment.
What's my date? 17. I'll adjourn this matter to June 17th, 2026, 9 a.m. Bond will continue.
Thank you. Bond.
Thank you. Court does call the case People versus Rita Bryant.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Bryant, who should be appearing via Zoom.
And I am attempting to make my camera come on, but it's not. Can you send that again? It's not letting me. Okay. There we go.
There it is. State your name.
Rita Bryant.
All right. What are we doing?
We'd be requesting to set this matter for final settlement conference, Your Honor, and I would be asking to address one bond condition when appropriate.
You don't want it this Friday.
We do not have to set it for this Friday.
Jury final settlement conference will be August
7th.
August 7th, 2026, 9 a.m. Jury selection will be August 10th, 2026, 8:30. Both of those proceedings are in person. All right.
In addressing bond, Your Honor, my client would like to request for her scram tether to be removed. Unfortunately, this week she was in a car accident, which is leaving her for a great amount of pain. She would understand that if the court would like her to use an alternative means of testing, such as a SoberLink device, or coming in to test. Just due to the unfortunate recent car accident, she's just in a lot of pain, and the scram tether is causing some extra concerns. She has not had any violations on the scram tether while on bond.
Response, please.
I just want to make sure that there is some form of alcohol testing. I know that alcohol was involved in this incident. I'll leave it to the court's discretion whether to keep it as scram or change it to a SoberLink.
I'll change it to with proof of medical regarding the accident. I will change it to a SoberLink tether 3 times a day testing. So you'll have to submit that to us along with an order to switch it over.
Understood, Your Honor.
All right. Thank you.
Thank you.
Court recalls case People versus Gregory Peterson.
Morning again, not Raymond Cooks for the people.
Good morning, Your Honor. Kevin Thompson appearing on behalf of Gregory Peterson. Stands to my right. Greg, please state your name again for the record. Greg Peterson.
All right. My understanding is that he's changing his plea to a no contest plea.
That is correct, Your Honor.
All right. And the basis for that is I'll indicate a lack of memory as to things, and I think it's appropriate in these circumstances to accept a no contest.
That is correct, Your Honor.
So you understand that a no contest plea means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
And you also understand that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. All the rights I explained to you apply to a no contest plea. You understand that, sir?
Yes, Your Honor.
All right. Sir, to that charge, how do you plead?
No contest, Your Honor.
All right. Court has received and reviewed Michigan Department of State Police report for their case number 3421-26. Any objection to the court having reviewed that report?
No objection.
The people, Your Honor, may I make a brief record as it relates to that report?
Yes, sir.
Your Honor, that report was furnished to the people this morning and promptly forwarded to defense counsel. I've spoken with defense counsel. My understanding is that he's had an opportunity to review it fully. I just want to make sure that was clear and on the record for the purpose of this plea, given the recent disclosure of that report.
And that is correct, Your Honor.
That is correct. All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine a defendant's guilt of this offense. Sir, I do have to apprise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to set aside your plea, and the court would not be bound by any sentence evaluation or record. You understand that, sir?
Yes, Your Honor.
Counsel, are there any other promises, threats, or other inducements which have led to this plea?
None from defense.
And have I complied with the court?
Yes, Your Honor.
Yes, you have, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Thank you. Yes. Defendants referred to probation for a pre-sentence investigation and report and consideration of any restitution.
Oh, just restitution.
Sentencing in this matter will be
July 8th.
July 8th, 2026, 9 a.m. Bond will continue. All right, sir, on your way out, if you can stop at my probation department so they can start that process. I should also indicate that ticket number 264686364 SI is also dismissed. Thank you
very much, Your Honor.
Thank you.
Thank you.
I'm gonna call the start with that one.
Court calls the case, People versus Craig Rosecrans.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defender Nick Bukovich on behalf of Mr. Rosecrans.
Is he here?
Yes, Craig Rosecrans.
Thank you. What are we doing?
At this time, Your Honor, I will be requesting an adjournment. Mr. Rosecrans is scheduled to be sentenced to the Runaway Recovery Court on June 12th, and that will have an impact on my negotiations with Mr. Cook here.
On June 12th, he's going to do that?
Yes.
I'll adjourn this to June 17th, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Braisha Anderson.
Morning, Your Honor. Raymond Cook for the people.
Carolyn Foster Tucker on behalf of Braisha Anderson. Your Honor, I don't see her in the courtroom and I don't have an explanation for her absence today.
Oh.
I would note that the defendant is set for a preliminary exam on June 16th. I don't know if that makes any difference to the court's consideration.
You won't be here that day either? Is that my day? Who's that before? Me?
Let me check.
You're not here.
Our case.
It's okay. Bench one release. If it's failure to appear, we can address it on that day. Bond 5,000, 10%. All right. Warrant will issue me that. Court does call the case, People versus Demond Brands.
Good morning, Your Honor. Trovia Star on behalf of Mr. Bransford, who's in custody.
Yes. Your name, sir? Demond Brands. Thank you. What are we doing?
Your Honor, I'm asking for an adjournment. I just received discovery this morning, and I was in the middle of filling out the green sheet, but I'm asking for an adjournment.
Is this the only thing holding you?
You know, he had a case this morning in Arbor, $1,000, 10% bond. He has some other cases as well. He has some cases tomorrow with you, and also 2 and 14B.
June 17th, 2026, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Yes.
Court does call the case of the people versus Spencer Rassick.
Morning, Your Honor. Raymond Cook for the people.
Morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Rassick, who approaches to my right. Please state your name.
Spencer Racick.
Hands out your.
All right, what are we doing?
Your Honor, I spoke with the people this morning. 3 of us actually had the referenced in the police report, so we're asking for a 2-week adjournment. Is that correct?
2 weeks should have to get that.
Oh, yes, more. 2 weeks.
Yes, Your Honor.
Adjourn the matter to June 17th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
This one.
So.
Got it. Court does call the case people versus Paul Ledger.
Morning, Your Honor. Raymond Cook for the people.
Morning, Your Honor. Please the Honorable Court, David Burgess on behalf of Paul Ledford.
Your name, sir?
Mr. Ledford.
Okay.
Your Honor, I spoke with the prosecutor this morning. There's he has a PCC up tomorrow as well as a couple of pending charges, Judge. So we're just asking for an adjournment to hopefully resolve all matters at one time.
Will the 17th work for you?
Get a bit more time. I see there's 2 pending cases in the warrant queue that was authorized and sworn to. So hopefully
July 1st.
try and make that work, Your Honor.
All right. Adjourn the matter to July 1st, 2026, 9 a.m. I would also indicate, and I don't know if you're aware of this, counsel, he's got a warrant out of 1482.
I'm only aware of the 2 pending, Your Honor, the PCC tomorrow and the.
It's a city case, just so that you're aware, for solicitation.
Okay. Thank you, Your Honor.
But I have and warrants to check right before I come in here. I don't have.
All right. Thank you.
They should have never been charged for solicitation before.
Okay. Is that a issued case?
Pardon?
That issued the warrant? Was it issued or was it pending?
The warrant.
It's active.
It's active.
Okay.
It's active.
All right.
Thank you. Court calls case people versus Jacob Simmons.
Morning, Your Honor. Raymond Cook for the people.
Sherilyn Foster Tucker on behalf of Jacob Simmons, present on the Zoom.
He's fine.
Oh, he is here.
Hello.
Sir, state your name.
Hi, Jacob Simmons.
Thank you.
Thank you, Your Honor. Your Honor, we're requesting to set this for final settlement. Mr. Simmons has indicated he wants to get me some information, so I was hoping we could do the August final settlement.
Without objection, jury final settlement conference, August 7th, 2026, 9 a.m. Jury selection, if necessary, August 10th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you.
You're all set.
Court calls case people versus Tasha Steiner.
Morning, Your Honor. Raymond Cook for the people. Oh, it's not Raymond Cook. Pattern still running. Township.
Yeah, right.
Good morning, Your Honor. Christina Saxon for Ms. Steiner. Ms. Steiner, please state your name for the court.
Dr. Steiner.
What are we doing?
Digital. Your Honor, Mr. Steiner made an offer. I'm sorry. Silly.
Just, all right, take a breath, start over. Mr. Schiller made an offer.
Mr. Siller made an offer, and I don't think he's had a chance to read my response to that. So that's why I'm waiting to see if he has a response.
Okay, so how long are we gonna wait? Because I don't have all day, but apparently.
Can we pass on this?
Well, how many more do they have to test out? One back and forth.
They have to read more after this.
Yeah, we better pass it. Conrad reads slow. So,
Yeah, email. That's the bad part.
all right, if you get back, I can bring out whoever's next. Court does call the case People versus Darrell Kubiak. Or Kabaki.
Morning, Your Honor. Raven spoke to the people.
Morning, James Talbot on behalf of Mr. Kabaki. Gerald, please say your name for the record.
Daryl Kabaki. I have a plea form that indicates that he'll be pleading to the charge of allowing another to violate the motor vehicle code, a 90-day offense. He'd be pleading to that added count 2. Count 1 would be dismissed. That's the court's full understanding.
That's correct, Your Honor.
That is correct, Judge.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Help you God. I do. State your name, please.
Daryl Kabaki. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of allowing another to violate the motor vehicle code. That's a misdemeanor punishable by up to 90 days, $100 fine plus court cost. Do you understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
To that charge, how do you plead?
Guilty.
So you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Anybody promise you anything other than what's been stated here today?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are indeed guilty?
Yes, sir.
March 6, 2026 at the location of westbound I-94, Pittsfield Township, Washington County, state of Michigan. Were you operating a motor vehicle?
Yes, sir.
What did you do that makes you think that you're guilty?
I was operating a motor vehicle on my way to work on 94.
Okay. So the other person or the person that you allowed to violate the motor vehicle code was yourself?
Correct.
Because you shouldn't have been operating that motor vehicle the way that you were, correct?
Yes, sir.
All right. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
You have it. What?
The court will accept the defendant's plea to count 2. Is there anything you or your counsel want to say before I impose sentence?
Not at this time, Judge. Just ask that the court immediate sentencing to fine and cost.
Fines and costs of $250. Order 90 days suspended. When can you get that paid, sir?
Today.
Today? Thank you.
Yes, sir.
Pay that today and then you're all set.
All right. Thank you.
Mr. Burdell, does that ring hurt?
Judge, feels fantastic.
Okay, no, you were just playing with it. And I'm like, geez,
Just fiddling.
is it just painful for you? All right. Take care, sir.
Thank you, Judge.
Court does call the case People versus Sean Charnley. It's not you.
This is the room.
Your name, sir?
Sean Charnley.
All right, Mr. Charnley, you are before the court on a misdemeanor complaint that alleges that on or about March 24, 2026, at the location in Pittsfield Township, that you did possess drug paraphernalia, namely a hypodermic needle and or syringes. Do you understand that charge, sir? Yes, I do. That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court costs. You understand that? I do. First question I have for you is, do you want to be represented by an attorney? Sure. Okay. All right. This is a public defender case.
Yes, Your Honor. Assistant Public Defender Bukovich on behalf of Mr. Chalney. At this time, Your Honor, as it relates to the charges, will be standing mute and waiving any additional formal reading.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. All right. What would you want an adjourned pretrial date then?
Yes, Your Honor.
Pretrial in this matter will be adjourned to June 17th, 2026, 9 a.m. As to bond. Are you held on anything else, Mr. Attorney? Plenty.
So I would ask for a consideration of a low cash bond for the purposes of credit.
Bond will be set $1,000, 10% bond. Will order standard conditions, including no assault, possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. That's all I'll set at this time. All right. Thank you, sir.
Yeah.
Court calls the case of the people versus Sapovan hard top.
Your Honor. That's all we have. The township in the matter. Bringing sugar to the people on file.
And Your Honor, Joe Simon, what happened? What happened?
What? Like the same height. I'm just shocked. I'm sorry.
I walked in. I walked in.
That was unnecessary.
I walked into it. Joe Simon on behalf of defendant said typo.
There you go.
Say your last name as well. Got that.
Okay. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of operating 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed.
Your Honor, that's true. We're also here for an arraignment.
Arraignment. Hold on a second. Was there an added count to this? No, the only reason I'm saying is pleading to an added count 3, count 1 would be dismissed. I don't see a count 2.
That might have simply been a type of record.
So it should be that he's pleading to the added count 2.
True.
Count 1. All right. And then you said you're also here on an arraignment?
This is an arraignment free trial, Your Honor. Yes.
It is. Okay.
Okay.
So as to the arraignment.
Waive formal arraigning, stand mute to the charges, and at the right time, we have a travel request.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. I have him sworn.
Raise your right hand. Do you solemnly swear the affirmative testimony you're about to give will be the truth, nothing but the truth of God? State your name.
Typo, got that.
All right.
Speak up a little louder.
Yeah. Sure, it is this court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. Court could order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor.
And still wish to plead?
Yes,
and to that charge, how do you plead?
Yes.
How do you plead? By pleading guilty, you will not have a trial.
Plead guilty.
Pardon?
Plead guilty, Your Honor.
He didn't say the word guilty, Your Honor, so now he's clarifying.
Okay. You understand that you will not have a trial of any kind. You signed an advice of rights form?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you your plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, sir.
of your own free will,
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense? On the date of March 14, 2026, at the location of 3000 Woodland Hills Drive, Pittsfield Township, Washington County, State of Michigan. Well, actually on Packard Road, I think, near Oakdale. Were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume an intoxicating? What'd you have and how much?
Had some beers and some shots, Your Honor.
All right. Were you stopped by the police? Or was there an accident?
No accident, Your Honor.
Okay, you were stopped by the police?
Yes.
Why'd they stop you?
I was changing lanes, Your Honor.
Lane maintenance.
Lane.
Okay. So some type of erratic driving as you were going back and forth? Okay. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital for a blood draw?
Yes.
And what were the results?
0.179.
0.179.
Do you have any reason to dispute those blood test results?
No. No, Your Honor.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Sir, I do have to apprise you that if I accept your plea, between the time I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? Counselor, you're aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. All right. Defendant is referred to Bounds Works for an alcohol screening and assessment. And
Let they know the court, he's done that. So
done that, that's right. And the victim's impact panel sentencing will be July 8th.
Your Honor, can we have the very next session? I will be traveling on July 8th. I'll be driving. Maybe I, zoom in from the car or something. Be better.
This is a trip your lovely wife is making you take?
Yes.
Then permission is granted.
Thank you, Your Honor.
July 22nd, 2026 at just noon or 9 a.m. All right. Bond in this case, I will set the defendant's bond in an amount of $20,000. Person of Lord excluding no assault, favor possessing weapons. He's also not to possess any alcohol, recreational marijuana, or any illegal drugs. I will also sign a community corrections order. He is to be placed on the sober link testing device.
Your Honor, does the court have
I do. All right. That's what I was going to ask.
Your Honor, with respect to that travel request.
Yes, sir. I thought it was yours, but go ahead.
Well, no, my client has prepaid travel to Colorado from June 12th to June 5th. He was fully expecting the community corrections referral. He knows that he would have to test while away if the court grants him permission. And he's going to make sure that he's adjusted to time when he's traveling.
Beautiful state, so I'll let him go.
Thank you.
I'll indicate the defendant may travel to Colorado. What were those dates again?
June 12, return June 15th? 15th, yeah.
12th through the 15th?
Yes, yeah.
All right. June 12th through June 15th. All right. That's it.
Thank you, Your Honor.
Thank you.
Wait for me. I'll stay in that book conference room.
What calls the cases? Is that it for you, Mr.?
It is. Thank you, Your Honor.
Have a good day. Court calls case people versus Shannon Giesling.
And Assistant Public Defendant Nicholas Buckovich, I'm having Ms. Kiesling. Okay. Needs the headphones, Your Honor.
That's right. We need
I'm sorry, Your Honor. Truth clear. Truth clear on me. Your Honor, East Lane was scheduled today for a review hearing, for the board to check the status of for the inpatient treatment. That correspondence that both myself and counsel received from the jail that assessments, access, sub-assessment days and Fridays. And she is on that list to be completed. It was my understanding last week that she was second on the list. So it's my anticipation that that would be completed today or this Friday. I have not got that in writing that that's what it would be this week, but that's my interpretation.
Yes, Your Honor, and I have been following up with Ms. Sarah Stewart along with Ms. Ferrara. I also have been speaking to Ms. Keating's family. They did find a place in Brighton that would be able to take her insurance to receive inpatient treatment. However, she would have to be released prior to that being able to be done because there's obviously questions for the assessment that they cannot answer on Ms. Keating's behalf. So obviously, I know Ms. Keating's family planned to be here today and has been here in support. So I understand she does have the support, but obviously, I was unable to get anything really moving in motion without having them be able to speak to my client directly.
All right. What I will do, I think, in this case is if you get that information and that's satisfactory, prepare an order for her release. But I need some documentation that that's a place that she could go to do treatment.
Your Honor, it's kind of tricky. It's kind of tricky with that because the treatment facility is not going to be able to say that yes, they have a bed
Correct.
for her until the assessment is completed. So that's where
Rules there.
yeah. So there could be, if she's released, there could be some delay with an appointment. And depending on how that assessment works for them, whether she would be assessed for the bed. Does that make sense?
Yes. The facility does its own assessment, right?
That's my understanding.
Yes. I guess. Court does call the case People versus Tanisha Moore.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Moore. I believe should be appearing via Zoom.
Yeah.
I did speak to Ms. Moore, and I know I provided the plea agreement in the court. So I believe she was supposed to be here today.
Tanisha Moore, she's not here.
If I could briefly pass this matter to try to contact my client.
Was she coming in person?
Yes, I know we received permission to Zoom, and that information was provided.
Fine. I wish I didn't like you. Court calls case People versus Quantity Thomas.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Thomas.
Your name?
Quay Thomas.
What are we doing?
At this time, Your Honor, we'd be asking for an adjournment. We are trying to work out a global resolution of these and her pending cases in the circuit court.
When's our next circuit court date?
I believe that was adjourned out about 2 weeks. I believe it may be the 15th. I would need to look at those cases.
So if I adjourn it out to the 17th, we're good.
Yes, we'll try to work out. Yes.
Yeah, June 17th, 2026, 9 a.m. Bond continued. Thank you. That was,
They're gonna bring the RICO up next.
okay, so they're ready on that. So
Yes. Mhm.
court does call the case Field versus Ryan Brown.
Counter and so on, yeah, it's still counted. Bring group of people in file, 23.
Ryan Brown.
Christina Saxon, 0610.
Ron Brown appearing on behalf of the other.
Okay, your name, sir? Ryan Brown. What are we doing?
Requesting adjournment, Your Honor.
Your Honor.
May 17th, 2026, 9 a.m.
Thank you.
Bond gets.
Thank you.
Court does call the case People versus Pastor Shiner.
Counter and so on, yes.
Good afternoon or morning, Your Honor. Tina Saxon from Ms. Shiner.
Your name again?
Pastor Shire.
Thank you.
Your Honor, we're asking for an adjournment on this. And Your Honor, can we set this out for about a month? Because
I don't mind doing that if council believes that's appropriate, but is she being held on something else?
yes, Your Honor,
Oh.
multiple cases with dates the end of June and July 7th. Our next hearings in 14B. And
Said July 7th?
June 30th and July 7th
Yeah.
are her next hearings there.
So you want this after those or?
Yes, Your Honor, we're trying to get a resolution.
I got you, but. So what would be my July date after the curve? July 15th. I'll adjourn the matter out to July 15th, 2026, 9 a.m. Bound continued.
Your Honor.
That it for the jail?
Yes, Your Honor.
All right, thanks, guys. Court calls case People versus Russell Norvell.
Bring on bring people.
Carolyn Foster Tucker on behalf of Russell Norvell.
Your name, sir?
Russell Norvell.
I have a plea form in front of me. Is that what we're doing?
Yes, Your Honor.
Indicates defendant will be pleading to two charges, counts 3 and 4, retail fraud, third degree, both 93-day misdemeanors. Upon successful plea to those charges, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes, Your Honor.
May I have him sworn?
Yeah. Now, I'm sure in front of me. Oh, truth and nothing but what we got.
Yes.
Station name, please.
Russell Norvell, the second.
Sir, it is this court's understanding that you're going to be pleading guilty to 2 charges of retail fraud in the third degree.
Yes.
Is that correct?
Yes.
Those are misdemeanors, punishable by up to 93 days jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Still wish to plead guilty to these, sir?
Yes, sir.
To the charge of retail fraud, third degree as contained in count 3. How do you plead?
Guilty.
To that same charge as contained in count 4. How do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I understand.
You signed an advice of rights form, is that correct?
That's correct.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Does anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Sir.
Date September 17, 2025 at the location of 3825 Carpenter Road in Pittsfield Township. What do you do at the Meyer that makes you think that you're guilty?
I tried to leave the store without paying full price for the items.
Okay. So without paying full price, what do you mean?
Tricking the scanner, I guess. So it rang up just not correctly.
So did you switch tags or something, or?
No, it was like a light paper crimp.
Pardon?
A light paper crimp angle, just the way that you would kind of brush it across.
Okay. And so you were manipulating the tag for the scanner to read in some way.
Yes.
And that resulted in the scanner giving a lesser price.
Yes.
Than what the item was actually worth.
That's correct.
Okay. And maybe, did you do that on 2 occasions at least? On that day?
Yes.
The date.
Yes.
So you did that twice?
I did.
All right. And then you tried to walk out of the store without paying for the item?
Yes.
Is that correct? And the store was open to the public at the time?
It was.
You didn't have anybody's permission to do this, did you?
No.
And okay, I don't need to value. All right. Sir, I do have to advise you that if between the time I accept your plea to these charges and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, the court would not be bound by any sentence evaluation or recommendation, and you could not withdraw your plea. You understand that?
I understand.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None of the people.
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to counts 3 and 4. Counts 1 and 2 are dismissed. Defendants referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be July 8th, 2026, 9 a.m. And will continue. Thank you. Sir, on your way out, please stop down in my probation department and check in so we can start the process.
Okay.
Thank you, Your Honor.
Thank you. Now there it goes. Court does call the case People versus Mohammed Mufud.
Your Honor, any people?
David I. Goldstein appearing on behalf of the defendant.
Mohammed Mufid. Thank you.
May I approach the clerk, Your Honor?
Second. You know, they haven't fixed that. Whatever.
Do you want to?
Yeah, we're gonna have to because. Okay.
Now, the other is that.
France.
Yes.
Monaco.
Well, Monaco, he's going to the Grand Prix, I believe. Is that right?
No, the horse show.
You're really going to Monaco. Okay.
Well, right. But
no, I get it now. Okay.
Yeah, but I mean, it's, he steps over the boundary and I don't want to be any issues. So I said France.
That's fine.
France is bigger.
And that was July
8th through the 12th.
July 8th. July 12th. All right. Yes. And the other issue.
Okay, the other issue, Your Honor, is that we're asking for a final settlement conference. I was told by Mr. Cook that it might be quite a while. I just indicated to the court that my client would like the earliest date possible.
Okay. The way they're selected here, the earliest.
Judge says, wow, that was insulting. After defendant's unexpected courtroom comment, most people try to stay on a judge's good side, but one defendant accidentally said something that made the entire courtroom stop. And then everyone started laughing. The defendant appeared before the court for a routine payment review. She still owed $825 in court fines and costs. The judge asked a simple question: when do you think you can get that paid? She explained that she was a school employee on summer break. She wouldn't return to work until the end of August. Once she started getting paid again, she hoped to pay about half the balance by the end of September and finish the rest soon after. The judge listened carefully. Instead of demanding the full amount immediately, he tried to help. He began working out a payment schedule that would fit her budget. But then the defendant added something she didn't mean to sound disrespectful. She said she hoped she could make payments because she didn't want to end up coming back to court again. The judge smiled, paused for a second, and jokingly replied, "Wow, that was insulting." Then he added, "First you told me you've got things more important than me, and now you're telling me you don't want to come see me, Judge?" The courtroom immediately burst into laughter. It could have become an awkward moment. Instead, the judge turned it into a lesson about understanding someone's situation. He asked how much she could realistically pay every 2 weeks. After hearing her answer, he created a payment plan of $100 every 2 weeks, starting at the end of September, giving her nearly a month after returning to work before the first payment was due. Then he explained exactly why. He knew she hadn't been working during the summer. He didn't want her first paycheck to disappear immediately into court costs. He wanted to give her time to catch up on life's expenses before expecting payments. The defendant thanked the judge for working with her. What could have become a tense courtroom exchange ended with both sides smiling. Sometimes the best courtroom moments aren't about shouting or sending someone to jail. They're about a judge using common sense, a little humor, and giving someone a realistic chance to succeed. What do you think?